So welcome to our webinar, Navigating Divorce and Separation Without Going to Court. So I'm delighted to introduce our speakers today. Alison is a partner in our Manchester office and is a highly experienced family mediator, arbitrator and lawyer. She is passionate about sorting out issues without attending court, and she is used to handling complex, conflictual situations. Alison will focus on the bigger picture and the best interest of the children. She is described as bringing her formidable legal brain and people skills to mediation and helps clients achieve good outcomes. Emma, the divorce alchemist, is the author of the Amazon best-selling book, How to Be a Lady Who Leaves, The Ultimate Guide to Getting Divorce Ready. A former lawyer and family mediator, Emma is the founder of Get Divorce Ready, the online self-study program, and the Absolute Academy monthly membership for divorcing women. Emma has been featured on BBC Radio, The Telegraph, and in Marie Claire magazine. Emma is also the host of the 6-Minute Divorce podcast. And Cam is the lead training and development lead at Parenting Apart, Reducing Parental Conflict. Cam is an independent social worker and has over 20 years' experience working in safeguarding children and adults in children's services and therapeutic support service. Next slide, please. So I'm going to hand over in a moment to Alison, who will talk about family mediation and using one lawyer. I will then talk about family arbitration. I'll then pass over to Emma, who will discuss coaching support, and finally Cam will discuss
hello everyone,
apart.
Sorry about that.
So
it's a bit of a
over
tall
to you,
order
Alison.
for me to cover family mediation and our one couple, one lawyer service in 10 minutes. So it's going to definitely be a whistle-stop tour and definitely an overview. So what is family mediation? Well, as many, if not all of you will know, it's a process in which an independent third-party facilitator, a trained mediator, helps separating couples to resolve whatever the issues are between them, commonly the arrangements for any children they have, financial matters, and if they are married, then also divorce. The mediation will usually take place in a series of shorter meetings, might be an hour and a half, 2 hours, but it can also take place in a smaller number of longer meetings, perhaps even one long day. Usually both of the couple and the mediator will be together in one room, which can be in real life or it can be online. But also mediation can take place on a shuttle basis when each of the couple are in separate rooms, or a combination of both. When mediation is conducted on a shuttle basis, then the mediator may be able to hold confidences between each of the rooms so that each of the couple can speak in confidence to the mediator, and that's something that would be agreed at the outset. Lawyers can be involved either giving advice in the background, in between meetings, or sometimes they can be involved in the meetings as well. And they will usually, but not always, draft the financial order if there is one, and a parenting plan or a child arrangements order if there needs to be one. And they can be involved directly by attending meetings as well, and that's commonly called lawyer-assisted mediation. And then there's also hybrid mediation, which I think as a term is commonly misunderstood. It's a type of family mediation, and it's usually, I think, best when someone talks about hybrid to just ask them what they mean by that, because it can mean sometimes that lawyers are involved. It can mean that perhaps there's going to be one long meeting rather than a series of meetings, or it can mean that it's a combination of shuttle and together mediation meetings, so with the mediator holding confidences. So because there is a lot of confusion about it, I generally would suggest you just check exactly what is meant by that if someone uses that term. So turning to our Separate Well with One Lawyer service, the one lawyer, one couple. This is an alternative to mediation, and it's a way of providing legal advice to both of the couple together rather than to just one of them, as has commonly been the case up until very recently. It is a new process. And when can it happen? Well, it can only happen if both of the couple have a sufficient substantially common interest that will outweigh the apparent conflict or risk of conflict that they may otherwise have. And they both have to give informed consent, and they have to agree to share all relevant confidential information. And we as the lawyers, so if I'm acting as the lawyer in this way, need to be satisfied that it's reasonable for us to act for both of them. And if all of those component parts are there, then the solicitor's regulatory authority agree that it is appropriate for us to act for both. So it's a different way of providing the same advice that you would provide to one of a couple, but to them together with obvious cost saving. And the key is screening at the outset for suitability. And that's also true of mediation, and not just at the beginning, but also on an ongoing basis. So how do you choose family mediation or our separate well with one lawyer service? Or sometimes, there are many other firms that offer it. Sometimes it's called resolution together. Sometimes it has other labels as well if firms have created their own service, but they'll usually be very similar. So both are going to be more cost effective, mediation and separate well with one lawyer, more cost effective than using two lawyers. There are many similarities. Now, as a mediator or a single lawyer, I'm going to be impartial and independent. It's a voluntary process, so both of the couple have to agree to engage in mediation or in a single lawyer advice service. Need to be able to work together, at least to an extent. Need to be willing to be open and honest, and either welcome guidance if it's a mediation or advice if it's a single lawyer service. There needs to be some level of trust between them. They are separating, so it's very common for there to be some trust issues, but there has to be enough trust for them to be able to work effectively in this way. And similarly, they need to be emotionally ready to work in this way, to be able to make decisions freely. So it's a very careful screening process to assess that, and also the balance of power. There needs to be a sufficient balance and or enough support in place. And it's possible also to go from mediation into arbitration. So if we can't reach an agreement in mediation, then to arbitrate. And likewise, you could do the same from a single lawyer service. So this cartoon, I think, illustrates how effective mediation or a separate well with one lawyer service can be. And happily, the majority of lawyers will encourage that to happen rather than not, unlike the two delightful individuals in that cartoon. So when would you choose mediation rather than separate well with one lawyer? Well, if the couple need help negotiating, then mediation is likely to be a better process. In a single lawyer service, actually, as a lawyer, I can't help the couple to negotiate. I just have to give advice, set out what the options are, but then it's down to them to make a decision. If one or both have very strong and differing views about the outcome, again, mediation is likely to be more appropriate. If they need to be in different rooms, again, a separate well with one lawyer is not going to be possible in that scenario. It has to all be done openly and together. So mediation would be better. If there's an imbalance of power, it might be possible to manage that in mediation. Similarly, if one or other needs additional support, mediation might be a better option. Mediation may be possible if there's domestic abuse. In some situations, it is not going to be possible to use a single lawyer service. If it might help the couple to reach an agreement for the mediator to be able to hold confidences, then that option is not available in a single lawyer service. Likewise, if there's a potential conflict in the regulatory sense, then mediation, again, better option. And finally, and very importantly, when I meet with couples who have children in mediation, I can also meet with their children. And there is a ream of evidence, as many of you will be aware, about how important it is for children and young people to be able to have a voice in their arrangements going forward. And so as a mediator, I can meet with them. I'm trained and qualified in child inclusive mediation. But when I'm acting as a single lawyer advising both of a separating couple, although I am the same person, I can't actually meet with the children and young people because our rules don't currently allow that. So that would be another good reason for trying mediation. Separate well with one lawyer, though, is really a very cost-effective service, and is ideal for people who really want that direction, want legal advice rather than just guidance to help them to reach an outcome. And it'd be particularly good if both agree what the arrangements or the settlement should be. So we provide a very cost-effective fixed fee service for couples who've already reached an agreement, or if they have agreed broad principles, but they need quite a lot of help with what that will actually look like in legal terms. If they're either of those two scenarios, then our Separate Well service is ideal. If both want to replicate what a court would do, some people aren't really that bothered about what a court would do and they want to reach their own agreement, but others are really quite concerned to make sure that they have an outcome that would be fair legally. And in that case, then this is Separate Well with one lawyer would be a good service. And of course, if there's no conflict, then again, a one lawyer service can be a very cost-effective way forwards. And then just finally, to bust some myths, I hear quite often that a case is too complicated for mediation or for Separate Well with one lawyer, and that's just simply not true. We have dealt with some very complex cases in both of those options, and high value cases too. So it's quite possible to draw in other expertise where you need it, so tax advice, real estate advice, international advice, and so on, into either of those processes. The second one, that it's not possible to mediate if there's domestic abuse. You can mediate. In some circumstances, if there's domestic abuse, it needs to be managed very, very carefully, but it may be possible. And the opposite to that is another myth that if people have mediated, there can't possibly have been any domestic abuse. Well, that's also not true, obviously. And then finally, if an agreement isn't reached, then the couple have to go right back to the beginning, start again, and all those costs will be incurred. Well, that doesn't have to be the case, because it's quite possible, for example, to progress to arbitration, where a third party will make a decision, which brings me very nicely on to hand over to Jane to talk about arbitration.
Thanks, Alison. Okay, so family arbitration is an ideal approach for people who want to resolve a family dispute and avoid delay and expense of going to court. It's not new. It's been available for finance disputes since 2012 and children issues since 2016. There's separate rules for each scheme, and it's becoming increasingly used because of the difficulties within the court. And in April 24, the definition of non-court dispute resolution has been expanded to include arbitration. And within the court process, the court will now actively encourage parties to undertake NCDR and adjourn court proceedings for this to happen if at all possible. Next slide, please. So family arbitration is voluntary. Both parties agree to be bound by the arbitrator's decision and agree that this decision will be turned into a court order by consent, making it enforceable. It provides certainty as the decision of the arbitrator is binding in the same way as a court order, and it can only be appealed if there has been a legal error or a serious irregularity. And the court will uphold the award or determination as long as it's within the accepted framework. And so in this way, the court will give effect to the parties' autonomy. The Institute of Family Law Arbitrators, IFLA, provides details of the practitioners who have undergone the specific training to be an arbitrator and who are on the family arbitrator panel. Have the next slide, please. So if you or your ex-partner have finance or children dispute that you wish to resolve without going to court, and you decide to use family arbitration to resolve all or part of the dispute, so the rest could be dealt with by a form of other NCDR such as mediation or collaborative, then the first step would be that you both choose the arbitrator from the IFLA website. You can filter the search by location and specialism. You can do this yourself, or you can each have your own solicitor. You would both complete and sign the forms. It's ARB1FS for finance case or ARB1CS for children. And if it's a children case, you also need to complete a safeguarding form and obtain basic disclosure from the DBS. You will then in the form specify the issues that you want the arbitrator to decide. There will then be an initial meeting with the arbitrator to discuss the format. So will it be in person, like a court hearing, or on paper, or if it is in person, remotely? You'll discuss the timetable and how the process will work and whether any expert evidence is required. After hearing all the evidence, the arbitrator will make a decision that will be sent out to you in writing together with the reasons for the decision. It's called an award in a finance case and a determination in a children case. Then after that, the parties have to request the court to make the award or determination into an order which is enforceable with limited rights to appeal, as I've explained. The next slide, please. So I've listed here the benefits of family arbitration. The first one is choice. The parties select their own decision maker from a formal arbitration panel. Continuity, you have the same arbitrator throughout the case. Autonomy, this will start with the parties agreeing to arbitrate and then deciding which matters will be resolved by the arbitrator, and then the discussion with the arbitrator how the case should proceed. Flexibility, it's a bespoke timetable and process. You can choose the venue and the times to suit you and your family. It can be used alongside other forms of NCDR, or court proceedings can be adjourned for it to take place. Confidentiality, so since the transparency pilot scheme was launched, there is now a presumption that legal bloggers and accredited media may report on family court cases, but arbitration remains confidential with no reporting. Speed, as we all know, the court is experiencing severe delays. Arbitration is quicker, so saving costs and reducing stress and uncertainty. Versatility, so it can be dealt with on paper, face-to-face, remotely. You can have your own solicitor throughout. Finality, at the end, you will have a legally binding decision. And cost, although arbitration does have a fee for the arbitrator, this is shared between the parties and the whole process can be less expensive than court. Next slide. So the case is suitable for finance arbitration. So an arbitrator has the same range of financial orders arising from a divorce or a dissolution of a civil partnership as a court can make. It also can deal with the 1975 Act, which enables an arbitrator to order financial provision out of the estate of a deceased person for their family or dependents. Section 12 of the MFPA is not used that much, but it's for financial relief in England and Wales after an overseas divorce. Schedule 1 is financial provision for children, and Talata is financial provision for unmarried couples. And underneath, I've listed some examples of cases not dealt with under the scheme. Next slide. Cases suitable for children arbitration, generally any issues between the people who have PR, parental responsibility, which includes where the child should live, who they should spend time with, holidays abroad, relocation in the UK or abroad, change of school, disputes over routine and non-life-threatening medical treatment, issues around religion, disputes with extended family members. And again, I've listed some examples not covered by the scheme, and this also includes where there are safeguarding issues. Some examples where family arbitration is used successfully is where speed is of the essence. So one party, for example, requires interim maintenance urgently, or in a children case, a decision needs to be made about a change of school before the academic year starts. To save costs, where the cost of the court process is not proportionate to the assets in the case. Delay, arbitration can be dealt with and organised much quicker than the court process. And you can combine arbitration with other forms of NCDR, as Alison explained. For example, if you've reached an impasse in mediation, it can be referred to arbitration, but the arbitrator may then refer back to mediation to help the parties implement the decision made. Okay, so that was my whistle-stop tour of arbitration, and I'll now hand over to Emma.
Hello. So If you need or you have a client that would require some coaching support, what is it and how can it benefit your client or you? So divorce coaching is a partnership designed to support the person going through divorce to stay future focused and plan for the life that they want for themselves and their children post-divorce, grounded in the reality of their unique situation with regard to the laws that are applicable to them. Now, many people come to the separation and divorce process when they're just not ready. So how can divorce coaching help them? Well, the first thing to say is that coaching is not therapy. It's very much future focused. And like mediation, it's not about rehashing the past. It's about helping the person thinking about what they want for the future for themselves and their family, whether that be in relation to the financial settlement or in relation to their children. It helps them keep their emotions out of negotiations. It fosters flexibility and helps people think creatively. So if you have a client who has got stuck, perhaps that there's some trauma there or there's some unmet need that the client can't move past, or you're experiencing that yourself if you're listening to this webinar, then consider some divorce coaching, because the coaching is there to help you get out of your stuckness and to keep you grounded in reality and help you plan family-focused decisions. So what does this mean? It means that when you start coaching, you're able to work one-on-one with a coach, bring anything to the table that you feel may be holding you back, may be keeping you stuck, to put aside all the anger and the hurt and the blame that you may feel or feel that you're on the end of, and focus on where you are now in terms of the legal process that you may be about to embark on, whether or not you have decided to leave the relationship, the other person has left the relationship, or whether it's a joint decision. Because separation and divorce is always hard, even if it is your decision. So having somebody other than your lawyer to discuss these things with can help you move forward. Next slide, please. So what are the benefits of coaching? Well, many clients need to feel supported and heard. And often, if they're in a traumatic relationship and it's not ended well, or there's been some domestic abuse throughout, the client can often feel overwhelmed, probably quite small and vulnerable. And so in coaching, they're able to get a sense of themselves and become more empowered. This enables the client to focus on their other responsibilities. That does include the parenting of their children and their work. Because as a divorce coach, I know that many people get so overwhelmed with the separation and divorce process that it becomes everything. And you do need to have a life alongside the divorce process. It also helps with post-separation relationships and helps them have healthier boundaries. If your relationship has been one of codependency or it has been toxic in some other way, healthier boundaries are going to help you move forward. Boundaries in relation to your parenting and also boundaries in relation to how you deal with money. Children also experience calmer, more responsive parents. So the benefits of coaching are that you get time for you get to feel heard, you get to feel your sense of confidence return, you get to focus on the future, you get to have a life outside the separation and divorce process. Your children are happier with more responsive parents, and it can help settle matters more quickly and save time and money. Next slide, please. So what types of clients benefit most from coaching? Well, all clients will benefit from some form of coaching, men or women, it doesn't really matter. But particularly clients in high conflict situations. And if you have a client in a high conflict situation, you might see it before your client recognizes it. And what do I mean by that? Many of my clients come to me and say, well, on balance, the relationship was okay. But then they start to tell me about situations that they're a bit worried about or a bit nervous about, or they're not really sure about how their partner is going to respond if they say this or if they say that, or they find themselves holding back in relation to truly exploring what they want from their future life. And it's often these clients that are in covert high conflict situations. And bringing that to the forefront is good for your client because it helps them understand the situation that they're in. It also helps them protect themselves, get additional support, because as I've mentioned, coaching is not therapy. And so a good divorce coach will signpost out clients to further trauma support if necessary, or to some IDFA services, or to the police if necessary. Clients in high conflict relationships need a lot of support. And there's often a tendency for the high conflict client to want to rely on their lawyer for support, which drains resources really, really quickly. And if your client is of limited funds, this can mean that just when they need your help the most as a lawyer, they run out of money. Often clients are reluctant to hire other professionals to help them in their situation. But I really do encourage clients to see that they need a divorce support team. And their lawyer is one of those, such as Jane and Alison. But people like Cam, who you'll hear from next, and myself are there as a team. And investing wisely in the right support at the right time can really save clients an awful lot of money. As Alison mentioned about power imbalances, divorce support can really help with real or perceived power imbalances. Often clients in high conflict and abusive situations come to the process feeling that they have to give in, that they have to kowtow, that they're not going to get anywhere. And helping them understand their role in the relationship and how it has come to pass helps them move forward. Other clients that also benefit from coaching support are clients where one or both of them may be neurodivergent. And this is because the divorce and separation process in England and Wales can often focus on a lot of paperwork, court applications, even if they're child-related only. There's a lot of paperwork to fill in. There are a lot of appointments to meet, a lot of things to feel that you need to get right. And this can be particularly overwhelming for clients who are neurodivergent. Having coaching support can help them manage their energy, get organised, have someone to check in with them, do some body doubling if necessary to keep them on track. If it's clients who are going through the divorce process and there's financial remedy to consider, coaching can help them get their Form E completed, ensure that they attend to all their statements at the correct time. Clients who have coaching feel supported. It means that they make the best use of their lawyers at all times. Clients where alcoholism and codependency are present can also benefit from coaching support. I notice from my clients that codependency is often the thing that keeps people stuck in relationships for longer than is healthy for them. Coaching can help them begin to unpick some of that, understand the separation and divorce process, and make good decisions for them. Sometimes not every solution is going to be applicable for every client, and helping clients feel like they have agency and choice enables them to move forward. I notice that with clients with additional needs, such as neurodivergency or codependency, are always grateful when they begin to understand themselves better, when they get the courage to move forward by asking for the support that they need, even when they feel fearful. When clients rely too much on their lawyers, they don't develop the skills that are going to be needed post-separation and divorce. Because one thing is clear, at some point, the separation and divorce process will end. And good coaching support can give them the tools that they need, and I'm sure that Cam is going to talk about this in just a moment, to move forward into their post-divorce relationships as co-parents. It also gives them a clearer sense of who they are in themselves, so they can step forward with confidence, so that they can begin to build a life that is right for them and their children. and having a sense of what that future may look like. I mentioned at the start that being grounded in reality is really important. And it's also important that the coaching client understands the basis of the law and what is possible and what is not possible. Clients who have unrealistic expectations are always disappointed, and good coaching support will keep them grounded in reality about what is possible and what is not possible. It allows them then to come into any negotiation environment, be that mediation or through lawyers, being able to put aside those hurts and blames and focus on the issues that a court would look at if they're not able to reach agreement. And this enables them to step forward with the confidence to say exactly what they do want and what they don't want, knowing that flexibility and compromise are just part of the process, and being comfortable with that while still honouring their own needs. Thank you very much.
Hi everyone. First of all, I just want to say thank you to Mills and Reeds to invite us and talk about our programme. Next slide, please. So, what is the Parenting Apart programme? We are an intervention. We're currently offering it through the legal system. We get cases from both public and private law proceedings and also from children's services. We're an evidence-based intervention, and what we do is we aim to improve outcomes for both adults and children. Next slide, please. So this is just a snapshot of some of the awards that we've won and also some of the recognition amongst children and young people and the family law awards that we've been recognised for. Next slide, please. So, often people ask us, who are we? What type of practitioners we are? I think it's really helpful for people to understand that when parents come into conflict, they need a different type of skilled practitioner to do this type of work. So a lot of our practitioners are trained in parental conflict. They have understanding and knowledge around child development, attachment. They are often have undertaken safeguarding training, and they often have experience of doing direct work with both children and adults. Our practitioners come from a range of different services, from the health, social care, family support workers, social workers, psychologists, and lots of other types of professionals that work with children. Next slide, please. Currently, the programme is being offered across 3 different local authorities. They offer the intervention as part of their early help, part of the reducing parental conflict agenda. And you may recognise some of these local authorities, and they're offering it as part of their early family help support. We also deliver support for CAFCAS. We're a provider of the IFCA and the services offered to private law cases where the court will order the family to attend the intervention. Next slide, please. These are just some of our findings from our early evaluations that we've undertaken. And one of the evaluations that's identified is that we're often seen as a last resort and not seen as a first resort. So often families are referred to us when they're entrenched in conflict, they've gone into legal proceedings, they've gone through various different types of family law proceedings, such as dispute, fact-finding. And what we're finding is that when families come to the end of their journey, it's often really difficult for them to move past some of the difficulties. This is just a slide just to tell you some of the outcomes that we've been able to achieve for children. Next slide, please. Also, what we try to do is, by doing this work, we're trying to give parents back their control and responsibility in trying to form a better co-parenting relationship. But also, what we do know, it is a traumatic experience, as Emma explained earlier on, for parents who are going through divorce and separation. And going through lengthy court proceedings can add to the trauma that parents and children are experiencing. So what we aim to do is reduce some of those difficulties and those emotional difficulties when it comes to developing a co-parenting relationship. Next slide, please. So the ethos of our program is really helping the parents to develop a parent mind, which is slightly different to having a relationship with your ex-partner, because most parents who come to us will hold a lot of baggage about their ex-relationship. What we try to do is support the parents to take a slightly different approach, because we know that parenting plays a huge part in how children's brain develop and the associated influences, that is how the child's cognitive, social and emotional life long term. So by positioning parents as parents rather than ex-partners, we support them to take a child-centered approach which encourages them to work together. Next slide, please. So we take a slightly different context to the work. Now, these are the different types of foundations that we support our parents. We take a very relational approach to our work. We focus on child adversity. We help parents to do some change work about changing their behaviours and really understanding the neurodevelopmental delays and the impact of conflict and the legal context can have on children and their families. Next slide, please. So we offer a range of different interventions. The 4-week intervention is really for those parents where they have got some kind of arrangements, but they're really just struggling how to formalise them. And these are often cases where there's no ongoing domestic abuse, all kind of safeguarding concerns have been addressed in relation to the child. They're not in family law proceedings. It's often offered as, it can be offered alongside mediation or after mediation, but also where the child is not resistant to having a relationship with the other parent, because that takes a slightly different element of work. Next slide, please. Our 8-week intervention is often for those families who have already got to the court proceedings and they often need a little bit more help to understand what is in the best interest of the child. And a longer intervention is often when lots of people have been involved, such as CAFCAS, there's been a fact-finding hearing, there's been safeguarding concerns, alienating behaviours. These are often families where they may have gone from private law proceedings into public law proceedings. What we try to do is we encourage parents to come to a free 30-minute consultation, because we think it's really important for parents to understand how we work in this process and what is the work involved with them, so they are sort of briefed more and more informed about the process of our intervention. Next slide, please. We take a 7-step parental engagement process. So anyone that's entering into our program, we have to do an initial risk assessment to see whether it's safe to do the work with both parents together. Then what we do is we do some individual work with each parent. These can be one meetings or individuals, it could be a number of meetings, really to support the parents to start coming together and thinking about how they're going to be working together. We do step 3, step 4 and step 5 together with both parents, and this can be done virtually or face-to-face. A lot of our work is now being offered virtually and parents can access that because obviously they're sometimes in different locations, or the child is living in one area or the other parent is living in another area. And we can also offer some practical help as well, because sometimes parents really struggle with going out in the community and doing those little tasks that they need to do, like transitions or supporting a child to reforming a relationship with the other parent. So we can do a lot of that stuff while we're doing the work with them. Next slide, please. What we do know is that divorce is an adverse experience in a child's development, but what we try to do is not make it a traumatic event. What we find is a lot of parents will come to us with lots of risk factors. Oh, the other parent isn't doing this. Lots of concerns about the other parent. What we try to do through this process is help them to develop some protective factors around the child and really begin to get them to think about some of the things that they are doing really, really well, and getting them to think about what does a supporting parenting approach looks like. which tips the scales to more protective factors and helps the parents to reduce their sort of trust, increase their trust in the other parent's parenting relationship. Next slide, please. What we do know is we help parents to really begin to think about how conflict becomes the bigger picture in their relationship, because conflict is both a behaviour and a communication. And how do they communicate that with each other when conflict becomes a big piece of their relationship? Next slide, please. So through our process, what we help them to do is really begin to think about their destructive communication. What does that look like? What does that feel like? How would that be experienced by the child? And what we try to do is help them to shift from this destructive place to a constructive, where they can have differences, where they can do different things, but equally feel able to discuss those things together in a constructive manner. Next slide, please. So in a nutshell, what we try to do with our parents is we help to develop their skills and their knowledge by giving them some psychoeducation around child development, attachment, adversity. What do safe relationships look like for children? And really getting them to think about the impact of their divorce, separation, and also the high conflict that brings the emotional difficulties for both children and also their parents. But also, we tell them what's going to be at stake, because like what Emma says, we have to ground them in the reality. We have to ground them into what's here and now and really get them to think about what their child's ongoing developmental needs are. And if conflict stays a prominent feature throughout the child's relationship, then it's going to have some difficulties as they grow into adulthood. Next slide, please. So the overall aims of PAP, really, I mean, there's lots of things there on the slides, and I'm sure you'll be able to see that when you get them. But what we try to do is really help parents to take back their parental responsibility, but also help them to understand the rights of their child, because their child should have a relationship with both parents, providing there's no harm or safeguarding concern. Next slide, please. And what we try to do is align this with evidence-based practice, which has also been highlighted in the private law subgroup, but also aligns with the Reducing Parental Conflict framework. And what we try to achieve, next slide. Fortunately, we do achieve this. So we do come out with a parent working agreement that the parents make together, which they can go back to court or go back to their solicitors and say, this is what we want for our children. This is our future, and this is what we would like for our children when it comes to making decisions together, when it comes to going to school and thinking about their time with each parent. Next slide, please. And this is just to tell you how you can refer into us and the different types of places you can access our support through.
Thank you so much. That was so interesting. Thank you. So we do have some time for questions. So the first question, let me see, I think this will be for you, Alison. How do you judge whether there is a sufficient balance of power within the couple?
So yeah, I mean, it's a really good question, and it's not an easy thing to do. And I think we have a set of screening questions that we ask at the outset, and then before any mediation, for example, there'll be a mediation information and assessment meeting, and that involves going through all of those screening questions, trying to understand the background of the family. The interactions between the couple, and there's some very detailed questions aimed at just trying to understand that dynamic. And those meetings take place separately. They are supposed to take up to an hour. I have to say, whenever I do a MIAM, it tends to take a lot longer than that, because I think it does take longer to really try and get under the skin of the situation. At the end of the day, though, we are carrying out what is a relatively brief exploration of what are people's very, very detailed lives and complex relationships. But one of the other elements I would say about both mediation and our Separate Well with One Lawyer service, where we will carry out a very similar screening process as well, is that there's a lot about giving people autonomy and the right to self-determination. And so after we've had those very open and honest discussions and have listened really hard to what our clients are saying to us, then it is a case of trying to work out whether they have got a sufficient balance of power. And power can be obviously many faceted. It might be, in a financial case, it might be that one of the couple knows a great deal more about the finances than the other. And that is a situation that can be addressed by the other person having additional support. So it could be legal advice, it could be financial advice, it could be both of those things. It could be having another family member potentially join them in the meetings who has a better understanding of finances. If it's in relation to the children, because it is still very common and it is still this way if it's an opposite sex relationship, that the husband tends to know more about the money, and the wife and mother tends to manage more of the children arrangements, that there may be a perception that the mother has very much more power with the children. And again, it's about exploring that with each of them and then working out what additional support is needed, because sometimes dads have not been that hands-on, and sometimes mums haven't been as well, but it does still tend to be that it's more dads that haven't been hands-on parents, and they may need some practical help as to actually what needs to happen for children to be comfortable when they spend time alone with dad, where perhaps more mum was around a bit more. And some of the support that is available, obviously, Emma and Cam have talked so eloquently about the benefits of coaching and a Parenting Apart program, would be thinking about whether that sort of support could be put in place. And if when we're talking about balance of power, it's very much about the relationship dynamic, then again, it's really about how to try and empower the person who is perhaps perceives that they have a reduced element of power in the situation, but also trusting them to make the decision about whether they feel comfortable to give it a go, and then keeping it under review and making sure they've got support. Many of our clients are receiving support from their GP. A lot of them will be on medication for anxiety or depression. They'll also be receiving therapeutic support from a counsellor or a coach, or sometimes both. And also from family and friends. So we will explore that in that first meeting. It's a very long answer to the question, but it's a difficult question to answer. And at the end of the day, there'll be a lot of cases where it's really clear that there is a sufficient balance of power to be able to mediate or to advise both of a couple together. And there'll be some really clear cases where there isn't. And the difficult bit is the bit in the middle. And we hope to do our best to get that as right as possible. And if we don't get it right, it does tend to become obvious quite quickly, and then that will bring an end to those processes, that process, and we will then signpost clients onto a more appropriate way of working to get an outcome for them.
Thanks, Alison, that was great. Question for Emma, please. Is coaching usually offered to both parents, or can one engage discreetly?
So you can engage discreetly. Most of my clients do. Some law firms do recommend that both parents go and get coaching, but it's obviously not something that they can be forced to do. And some people are very reticent because they don't understand what coaching is and the benefits of it. I believe it's better for each parent to have a different coach. I've worked with parents, same-sex parents who I was coaching one party and someone else was coaching the other. And that enables the client that the coach is working with to develop a completely confidential and safe space to explore whatever's going on for them, free to do so without any concerns. Often the coaching relationship takes a different direction to the one that both the coach and the coachee think it's going to, and can uncover all sorts of things, including domestic abuse that has not been recognised. So yes, you can do it together, and both parents can certainly engage in it. My preference is that I just deal with one parent.
Thanks, Emma. Some great questions. Thank you, everybody. So, Pam, a question for Pap. Do you have anything to offer if parents will not meet?
I think the individual meetings are really critical within our work, because we do sometimes have parents who we find that can't go into joint meetings because of some of the difficulties that Alison's explained, but also Emma's explained as well, that, you know, there might be some dynamics around the power imbalance, but also a parent's emotional capacity, because they're so still struggling to overcome some of their own stuff, emotional stuff and relational stuff that hasn't been processed at the moment. So what we try to do in those cases where the parents have engaged is we will do some individual work with them and really begin to get them to think about each other's perspective individually. So we take those systemic ideas again. Tell me a little bit about, how do you think mom or dad, if they were sitting here, how do you think they would be thinking about this? Or how do you think your child would experience this? So we don't just take it from an individual perspective, we will try and take a more holistic family approach so that that person can still think it from another person's perspective. I hope that sort of covers what I'm the question type thing.
Yeah, it definitely does. Thanks, Cam. Another one, Alison, for you. What is the process for child mediation if there are no court proceedings in place?
I think actually child inclusive mediation, well, in my experience at any event, tends to take place more frequently where there aren't court proceedings in place, because as soon as you're into a court process, then there are likely to be other professionals involved with the children. So a CAFCAS officer, for example, that's the court-appointed social worker who will meet with both of the parents and the children, usually if there's a court application. And so if I am talking with parents about me meeting with their children so that they can have a voice, if there are likely to be other professionals involved, then I think we need to think very carefully about whether that's the right thing for those children and young people, because, you know, they're having to tell their story many times, and it can be quite confusing it's confusing enough for parents as to what all of these different professionals do and how they can work with their children. So, and child inclusive mediation is very much about the children having a voice in what they would like their arrangements to be, in confidence, with a mediator who is not going to report back to anybody unless there are any safeguarding concerns, unless the children specifically authorise me to do so. And I will always, at the end of that meeting with the child or children, agree with them exactly what I can report back to their parents. And it's a common misconception as well that mediators can be ordered to write a report for court. We don't do that. The feedback is not given in writing at all, and there will not be a report given to court. It is a confidential process. So it's very different. Hopefully that answers the question.
Yeah, thank you. Pam, what consideration is given to families that have children with special needs? So, i.e., third-party input such as doctors, SEND teams, medical guidance, etc., requested?
Okay, so when we're working with families, we again like take a very holistic approach. So if there's other professionals involved, such as school therapist, assessments that are being taken with children, what we want to do is look at those assessments, and we want to get involved with those professionals to get an understanding of the child's experience and life around that. So we often speak with those professionals together, especially if they're in a child in need or child protection plan, or even if there's CAFCAS involved, we'll speak with them and understand what does that look like for the child. We also we often normally ask for an educational house plan as well, because that is often, especially for a child with a special needs, they'll have an educational house plan as well. We often ask parents to see that so we can support them in the right way.
Great, thank you. So another question, I think it probably have to be our final one, is how can you encourage someone who is not willing to engage in mediation to take part? And I wonder, Emma, if that would be something you would help encourage somebody with if they came to you for coaching, if that's within that remit.
Absolutely. So sometimes people come to coaching and they will have the myth in their head that Alison talked about, is like, I'm a victim of domestic abuse, I cannot mediate. And so then it's my role to look at what their fears are and explain to them how the process works and the safeguarding in place. And obviously, since April of this year, explain to them the consequences if unreasonable requests for non-court dispute resolution are not made out. So taking somebody from I'm not doing it, I just want a court outcome, how do I get to court? Often people come, as you know, to the process going, I just want to get before a judge. And it's about explaining what will happen if you get there. Lots of people still believe that they're going to get recompensed, that they are going to be heard by the court. And I remind them that, the court doesn't sit in moral judgment of people. The court process often does not feel fair. It is unlikely that you'll feel that, quote, justice, whatever that is, has been done. And if you end up going right down the court arena, a decision may be made for you that you have no control over at all. And therefore, why don't you try mediation? Go to one session, you'll learn something about yourself and the other person and how they are approaching this. And that's a bit of information that you can take forward if it is not suitable for you, if it doesn't work. But if you want to think about having some autonomy about the process, that's where you need to start. But people often feel that they have to mediate when they're not emotionally ready. And yet, when they do that emotional work first, they can reflect differently on whether or not they should mediate. Some people mediate and say, it wasn't good, the mediator was rubbish, we didn't get anywhere. And actually, it's not the mediation process that wasn't good, it's what they were not emotionally ready to engage because they're still angry, they're still looking for retribution, they're still looking for recognition. And that isn't the process of mediation. So it is about unpicking what that process will do for you and what the consequences of not engaging in it might be.
That's really interesting, thanks. Right, well, I think we've come to the end of our time. Thank you everyone for attending, and thank you especially to our speakers. It's been so interesting, so informative. And just to let you know, if you want any more information about the topics we've just been discussing today, find us at the M&R website in our Family and Children page, and also on LinkedIn. And we have our Explaining Family Law podcast on LinkedIn too, which is really worth listening to. Okay, thank you everybody. See you soon.